Hello, happy Friday. Sorry about the delay in the lecture. JAS 423 students, I hope you're all doing well. Beard's a little longer. Stressed a little bit more. As you can see, I'm here in the office. It's starting to kind of feel this is going to go on longer than I thought it would. So, yeah, not great. But anyway, today I'm going to lecture off the slides that are posted on week 13, rules 16 to 19 on the small claims court slides. Basically, I expect this to go about 20 minutes because I have a little bit of a deadline. Alana, my fiance, doesn't like me being out in the public for too long, given COVID-19 numbers are higher. I can't blame her, and the fact that I have this little cough still. Again, nothing else except the nagging cough that I usually get for 3 weeks after a cold. So I don't think, but I should get back in under social distance quarantine. So let's get through this quickly, shall we? And realistically, it's not. Oh, there's the bobblehead collection. Realistically, we shouldn't talk about it too long. It shouldn't take too long anyway. So very quickly, notice of trial, Rule 16. Rule 16, slide 5 on your deck. Slide 6. It's basically the rule that, who fixes the court date, the trial date. The clerk shall fix a date for trial and serve a notice of trial on each party who has filed a claim in defense if we've had a settlement conference and the party has requested that the clerk fix a date for trial and has paid the required fee. And notice of trial shall be emailed or faxed. You can most certainly state that this will probably be done email after the COVID-19 crisis. Just a little update I saw today in a notice to the profession from the Superior Court. Service by email is now allowed. So there's no coming back from this. We will be serving by email shortly. Okay, moving on to Rule 17 with regard to the slides, a small claims trial. And small claims trial has the characteristics of any other trial in our common law system. You will see this as you work there and you come to witness so many trials, different advocates, different styles, all that sort of stuff. So I included on the slide 8 a quote I used from Lord Denning, the great justice from the United Kingdom, who you have undoubtedly heard of. I include this in my small claims classes for paralegals, but I wanted to keep it here for you too. The advocate has a duty to the court which is paramount. So I put it here because you have that same duty. It is a mistake to suppose that she is a mouthpiece of her client to say what he wants or his tool to do as he directs. He is none of these things. He owes allegiance to a higher cause. It is a cause of truth and justice. He must not consciously misstate the facts. She must not knowingly conceal the truth. She must produce all the relevant authorities, even those that are against her. He must see that his client discloses, if ordered, the relevant documents, even those that are fatal to the case. She must disregard the most specific instructions of her client if they conflict with the duty to the court. The code which requires a barrister to do all this is not a code of law. It is a code of honor. If she breaks it, she is offending against the rules of the profession and is subject to discipline. So again, obviously different context for yourselves, but and that's cases Rundell and Worsley from 1966 at the English Court of English and Wales Court of Appeal by the great Lord Denning, M.R., which means Master of the Rolls. And that was basically He was the most senior judge ever not to sit in the House of Lords, the highest court over in the United Kingdom at the time, on account as he wanted to see the law. He wanted to do the law, and sitting at the English and Welsh Court of Appeals had him do a lot more law. So pretty cool. But anyway, it's just you have this duty as well. When you're functioning in the court system, you need to ensure that you act in an honorable and professional fashion at all times. So I just included it because I wanted you to see it. But anyway, the order of the trial, the examination, cross-examination, re-examination, submissions, and the judgment follows there. So that's kind of how the trial works. Let's then turn now to our rules and just sort of look at anything in particular that you that comes across here. So a failure to attend. If an action is called for trial and all the parties fail to attend, the trial judge may strike the action off the list. So if neither side wants to be respectful of the process, it's gone. I don't know how often that happens, but anyway. If one party fails to attend, however, you can proceed with the trial, and the judge may proceed in the absence of that party. If the plaintiff attends and the defendant fails to do so, strike out the defense, dismiss the defendant's claim, if any, and allow the plaintiff to prove subject to sub-rule 3. If the defendant attends but the plaintiff is given up, dismiss the action, allow the defendant to prove the defendant's claim, if any, and make any orders that is just. So basically, you can see if one side doesn't show, there can be considerable issues to deal with. Sorry. If the case described in clause 2, A, B, A, or C, the person with the claim is not required to prove liability against the party who has failed to attend, but is required to prove the amount. So, all right, you've won almost by default judgment, but in a manner, but you're going to have to prove sort of the amount, and so on. So let's look at 3 in the case described in clause 2. Bravo. If an issue as to the proper place of the trial and raised in the defense, the trial judge shall consider it when making a finding. So we're dealing with proper place. We've talked about that in the past. And setting aside or varying a judgment. The court may set aside or vary on such terms that are just a judgment obtained by a party who failed to attend the trial. So, yeah, it's basically that. I mean, conditions on making an order under sub-rule 4. Sorry, I'm just trying to... Conditions to order, making an order under sub-rule 4. The court may make an order under sub-rule 4 only, so varying the judgment, only the party who failed to attend makes a motion for the order within 30 days of becoming aware of the judgment. Okay, so if you're going to ask for it to be set aside or varied, then you better come within 30 days. You have to move quickly on it. Becoming aware of the judgment. That's interesting. Becoming aware. It's not sort of the actual date itself. It's becoming aware. And the party who failed to attend makes a motion for an extension of 30-day period mentioned in clause A, and the court is satisfied that there are no special circumstances. So there you go. 17.2. The court may postpone or adjourn a trial on such terms as are just. Pardon me, I'm going to open the office door. Ooh. Sorry about that. It's on the weekends or when the building is not in use. I think they turn the air conditioning off or they turn the heat up or something. So I just opened the door. It feels a lot better here. So okay, so the court may postpone or adjourn the trial on such terms as are just, including the payment of one party to another of an amount as compensation for inconvenience and expense. So it can be adjourned, of course. And look at the rule below. If it's been adjourned 2 or more times, any further adjournment may only be made on a motion. And the trial judge may, in the presence of the parties and representatives, inspect any real or personal property concerning a question in an action. So, okay, so that's about it. Let's go through to Rule 17.04. Within 30 days, a party may make a motion for a new trial within 30 days after a final order is made. Okay, a motion for a new trial. It's going to have to be very serious, but it can happen. In addition, with filing a notice of motion and supporting affidavit as to why a new trial should be given, basically the transcripts. It's going to have to come there, going to have to be delivered, and that has to include the reasons or judgment and a portion and any other portion of the proceeding that is relevant. The rest having to do with serving and filing the transcript and the powers of the motion court. 17.4 sub 4, on the hearing of the motion, the court may, if any party demonstrates the condition referred to on sub rule 5 is satisfied, grant a new trial, pronounce the judgment that ought to have been given at the trial, and order the judgment accordingly, or dismiss the motion as the case may be. The conditions required for sub 4 are: there was a purely arithmetic error in the determination of the amount of damages awarding. There is relevant evidence that was not available to the party at the time of the original trial and that could not have reasonably been expected at the available time. So, it's going to have to be very serious to do that. But it's either a calculation, arithmetic error, or, relevant details have sprung up from there. So, yeah, there you go. Is there anything in summation here that we need to look at for Rule 17 at the trial? No, I mean, it doesn't really sort of map out how the trial is going to actually happen, but it does sort of give you sort of the ins and outs of what can happen there. Yeah, so that's sort of it. Evidence, let's go now to Rule 18, so we'll just flip through here. Motions for a new trial, evidence, what can be brought there, powers of the motion, conditions. So the slides are very clear at this. Rule 18.1 and 18.2. Okay, so what do we get into evidence at a trial at small claims? Screen looks a little dark. Anyway. At a trial of an undefended action, the plaintiff's case may be proved by affidavit unless the trial judge orders otherwise. So to speed the process up, we can bring in written, sworn evidence by way of an affidavit. Rule 18.02, written statements, documents, records. A document or written statement or an audio or visual record that has been served at least 30 days before the trial date on all parties who were served. So with the notice of trial shall be received in evidence unless the trial judge orders otherwise. So a written statement, documents, or records within 30 days of the trial. Let's just, we do this to give the other side a fair amount of time, 30 days at least. I mean, that's sort of the bare minimum. But, any party should get it out much sooner than that if it is possible, of course. But that's it. And, just kind of go through here what is, what needs to be brought along with any evidence here. So sub 3, the party who serves another party a written statement or document described in sub rule 2 shall append to or include the statement, the name, the number, the witness, all that sort of stuff. So the information that's needed for that individual to be properly identified. And a party that has been served with a written statement or document described in sub rule 2 and wishes to cross-examine the witness or the author may summon her or him as a witness. So there is an allowance for cross-examination, which, as we know from case law, an American jurist, I forget, is the best way to the I'm going to find the direct quote. Sorry about that, I'm back. I found a couple cross-examination quotes that you will enjoy. The first is from John Henry Wigmore. Wigmore on evidence is a very famous American evidentiary textbook on evidence. But anyway, quote, the cross-examination is the greatest legal engine ever invented for the discovery of truth. You can do anything with a bayonet except sit on it. The lawyer can do anything with a cross-examination if he is skillful enough not to impale his own cause upon it. And then just to follow that up, I found a great one too. I trust he will conduct his cross-examination with all the added bitterness of an old friend. From Oscar Wilde, on learning that Carson, who had been briefed to defend the Marquis of Queensberry in a libel trial. So anyway, great ideas about cross-examinations for you, and basically this is it. So you bring in sort of this witness, the witness or the author, then they can be cross-examined on that. Where the witness or author is summoned, the person who, let's look at sub 5, a party who serves a summons to witness on a witness or author referred to in sub 3 shall, at the time the summons is served, serve a copy of the summons on every other party. So just make sure everyone knows who's coming to the party. And a party who is not served with a copy of the summons in accordance with sub 5 may request an adjournment of the trial. So I just take that again. A party who is not served with a copy of the summons in accordance with sub 5 may request an adjournment. You need to know what's going on. So just moving through, summons to a witness, any part, look at 18.031, summons to a witness. Any party who requires the attendance of a person in Ontario as a witness at the trial may serve that person with a summons to witness, Form 18 Alpha, requiring her or him to attend the trial at the time and place stated in the summons. So you can bring that person, you can summon that person to come to court for the purposes of the trial. The summons may also require the witness to produce at the trial any documents or relevant matters, things in his or her possession, control, and power relating to the matters in the questions. It shall be served in accordance with Rule 18.01, the summons to witness. The service of a summons and the payment of a tender of money may be proved by affidavit. And basically the interpreter here, it's always interesting to have an interpreter in the court. It's almost like an additional sort of layer of understanding. There's an old saying that when President Richard Nixon went to China to meet Chairman Mao, it was generally understood that Chairman Mao had a decent understanding of English, but he required a Chinese interpreter in the meeting, so he would have that added time to consider what to say to President Nixon. Again, I've read that a couple times. I don't know if it's true, but it is sort of an interesting little element there. And I've been in the room with a translator, and it's very different. It's a different dynamic, because what I have found is that the translator can sometimes almost sort of, by putting a neutral spin on it, they lessen the harshness of the lawyer asking questions. So again, that's just what I saw. Other lawyers, paralegals, may think a little bit differently about that. But anyway, that's it. So what happens when a party fails to attend? What identification? The party who served the summons on the witness may file with the clerk an identification form to assist in any apprehending of the witness. And what happens, basically failure, or if you need to be brought by way of the power of the state, i.e. the police. And of course, if there's a summons to witness that's abused, that's going to have serious repercussions. So let's just quickly look at costs here, and then next week we'll look at the federal court and the enforcement of orders later. So let's just look at costs. Rule 19 costs, and this will be done very quickly. Disbursements. Successful parties entitled to have parties' reasonable disbursements, including any costs affecting service or preparing a a claim or defense and expenses for travel, accommodation, photocopy, experts, reports, etc. So there's definitely costs involved. The clerk can assess the disbursements in accordance with regulations under the Administration of Justice Act in accordance with sub-rules 3 and 4. The amount of disbursements sub 3, the amount of disbursements assessed for effecting service shall not exceed 60 for each person served unless the court is of the opinion that there are special circumstances in justifying a greater amount. So they're going to keep it, and you've probably seen this theme around the ancillary costs that come with a small claims matter. There's sort of a fixed level on what costs can occur unless there's sort of extenuating circumstances. The court is of the opinion or special circumstances, let's call them that, as the book does. And the amount of disbursement assessed for preparing a plaintiff's or costs shall not exceed $100. And there's a limit on costs in accordance with the any power under this rule to award costs is subject to Section 29 of the Courts of Justice Act, which limits the amount of costs which may be awarded. And then finally, here we will look at the final rules of 19.05, compensation for inconvenience expense. The court may order an unsuccessful party to pay to a successful party who is self-represented an amount not exceeding $500 as compensation for inconvenience and expense. And finally, if the court is satisfied that a party has unduly complicated or prolonged an action that has otherwise acted unreasonably, the court may order the party to pay the amount of compensation. So let's stop it there with Rule 19. And I'm actually at this time, let's just do a check, time check. It's 22 minutes. Okay, so we're now at 22 minutes. I'm going to mark this on the blackboard as the point in time where we look at Rules 16 to 19 quiz. Okay, so as of now, we are taking up the quiz. So let's have a look. Rule 16, what are the preconditions for a clerk fixing the date and serving notice of the small claims trial? That is, your conditions precedents are A, settlement conference, and B, a party has requested. So that is question number 1. Rule 17, trial. Let's look at it very simply. What actions might a judge take if a party fails to attend their trial? I have that answer at 17.01, failure to attend, and you can list those there. A, called to trial. The trial may strike the action off the list. If an action is and a party fails to attend, sub 2, list those ones there. So A, B, C, D, 21 all the way down. So what actions might a judge take if a party? So in that sort of situation, on a final exam, for example, I would look for, what actions might they take if a party, that's both parties, right? We're looking at both parties there. So you would include the whole answer. Can an individual who missed their trial ask the court to set aside or vary the judgment? What conditions are required? Okay, with that one, again, I have sort of, let me just sort of check here. Let's go down to sub 4. Setting aside, the court may set aside or vary on such terms as are just obtained against a party who failed to attend a party. The conditions are the court may make an order, and you do that sub A and B, and so on. So that would sort of be it. So 17.015A and B. Okay. Let's look at question 3, but first let's look at the fact pattern. John Smith is the defendant of a small claims action and wants to adjourn his trial. The plaintiff, East End Comics, sold John a copy of Fantastic Four #1 from the early 60s. Love to get my hand on that. In near mint condition, that's an expensive book, for $25,000, and John has refused to pay $20,000, the amount of the claim. So, maybe a down payment of $5,000 with promise to pay later. 20 and it hasn't happened. So okay, so John is the defendant and he wants to adjourn. Okay, so let's look here. So adjournment, let's go to 17.021 at the top of page 2051. The court may postpone or adjourn a trial on such terms as are just, including payment by one party of another of an amount as compensation for inconvenience and expense. Okay, so what rule applies to any adjournment there? So John wants to adjourn the trial, and he can, they may postpone. If the trial has been adjourned twice or more, then John is going to run into serious problems, and that's sort of sub 2. That's question 4. What will happen if he's adjourned the trial already? Okay, well, if he's adjourned it once already, okay, maybe. Yes, but sorry about that. I got to get out of here soon. There's a crisis out there. Okay, so what will happen if he's adjourned it already? So just, if there's, if that is a tactic that John is using, it just continual adjournments, it's not going to be acceptable to the court. And because just look at question number 5. Can the judge inspect Fantastic Four number 1? What rule applies? Absolutely. 17.01. In the presence of the parties or their representatives, the trial judge may inspect any real or personal property concerning the question arising in the action. So you see real or personal property. You see this as sort of a field trip. But, Fantastic Four 49 can be... Hold on. Okay. Fantastic Four 49 can travel with you, eh? Lawyer who keeps comic books in their office. I'm the best. Okay. I'm kidding. So, yeah, I think generally speaking, we'll look at that as more sort of a real property matter, but you get the idea. Let's move on. John lost his trial against East End, and the judge made an order for him to pay the store $14,000 plus costs. John discovers that the Fantastic Four book was a forgery, and he was swindled. What steps can John make to remedy this error? What must then happen? What rule applies? So I would say, motion for a new trial. So let's look at 17.041 with the sub 5 conditions. This isn't an arithmetic error. This is relevant evidence that was not available at the original trial. So we look at sub 5, clause 2 there. Okay, and evidence at trial. We will... how does a party get a witness to come to small claims? They're going to be summoned, right? So where is it? Summons to a witness, 18.031. That's how it comes there. And assuming the party doesn't want to come on their own volition, they may serve summons to witness that way. When dealing with a witness statement, what information must be included? Let's go back to Rule 18.01 sub 2, 3, details about an author, the party who serves another party, a written statement or document described in sub Rule 2 shall append to the include a statement of the name, information, and witnesses. What party wishes to when a party wishes to cross-examine an individual on a written statement I wrote this without, in the comfort of my own home, which is not comfortable because it's difficult to work at home. So, what happens if a party wants to cross-examine? They may, of course, do that. And let's look at 1802 4. Sub 4, a party that has been served a written statement or document described wishes to cross-examine, they can do that. And what may a party do if they have not been given a copy of the summons to witness? And they can ask for, and where is it? They can ask for an adjournment. Okay, they can, okay, right over here. Party who is at 7. The party who is not served with a copy of the summons in accordance with sub 4 may request an adjournment. And who is responsible for providing an interpreter to a witness if one is required? Let's go there, and interpreter, where's interpreter? There it is. Okay, so 18.031 5.1 interpreter. If an party serves a summons on a witness who requires an interpreter, the party shall arrange for a qualified interpreter to attend at trial unless the interpretation is from English to French or French to English, and an interpreter is provided for by the Ministry of the Attorney General. Okay, so more questions coming. I will aim to get the next video out earlier. We're at 31 minutes, so I want to get going and get back to the safety of my place. But anyway, stay safe. Good luck. It's hard for all of us. It's becoming increasingly harder, I think, for me. It's just I miss my clients, and as you know, I'm a sort of a small sole practitioner lawyer, so it's tough. It's tough. But be well, be safe, and I will speak to you next week. Have a great weekend.